right, welcome. Thank you. It is, let's see, what is today? June 5th, 2024. We are Division 4 of the Colorado Court of Appeals, and we have two cases set for this afternoon's docket. One at 1:30, and that one's People versus Castro Velasquez, and one at 2 o'clock, and that one's People versus Pantaleon. So counsel are seated at the table, and I'll just go through very briefly, quickly. If you have any questions, please feel free to let me know. Just a reminder that arguments are 30 minutes. Each side has 15 minutes. Counsel for appellant, if you'd like to reserve time for rebuttal, please keep an eye on the clock. That's up to you to stop yourself. We will do our best to be mindful of your time, but if we're in the middle of a question, we may go over a little bit into your rebuttal time. And there is a toggle switch on the lower right of the podium, so it can be raised and lowered to ensure that the microphone can pick up your arguments. Everything is being recorded and archived, so please, we want to make sure that we have a good recording. Also be mindful, because we are archiving everything, if there's anything confidential that you do not want permanently on the internet, then be mindful to use initials or other non-identifying information. Let's see. Oh, my name is Judge Pawar. To my right is Judge Navarro, and to my left is Judge Johnson. And so when you are ready, unless you have any questions, when you're ready, please proceed. Thank you.
May it please the court, counsel. I have been trying to break this argument and break this case down into nice, discrete elements for the Miranda analysis, for the Harris analysis.
Could you enter your parents, please?
I'm sorry. Todd Narum, registration number 33186, on behalf of the defendant, Angel Castro Velasquez. I apologize, Your Honor. Getting excited myself there. So I was trying to break this down into a discrete Miranda analysis, Harris analysis, totality of the circumstances analysis, and I kept coming back to a problem where they're all like a bowl of spaghetti. Everything to me is linked with everything else. It's not a discrete totality of the circumstances, custodial interrogation analysis. I think everything in this case kind of came together. And the reason it came together was the telephone call between Detective Marples with the Boulder Police Department and Mr. Castro on the night of February 4th, 2000. At that time, about 43 seconds into the interview, Detective Marples introduced himself, spoke with Mr. Castro, and said to the effect of, I was going to see if you could come to the police department so we could talk face to face. But instead, he kind of acknowledged that Mr. Castro was at work and wouldn't be able to make it that night. Asked him if they had time for a telephone call. They spoke for about 15 minutes. And about 11...
Counsel, before you continue on with this chronology,
Sure.
I just want to be clear, make sure I have it clear. All of this conversation happened while Mr. Marples had the subpoena.
I believe he had the 41-1 at the
41-1.
time he made the phone call in the evening, which was approximately I don't know the time.
He had obtained that before.
I believe so.
So he had
yes.
it in hand. He was contacting Mr. Castro Velasquez because he had the warrant, the 41-1, and he was reaching out to him under that.
Correct.
Okay.
And he didn't initially tell Mr. Castro about the 41-1 order, but about 11 minutes into the conversation, he brings up the issue of DNA. And at 11:51 approximately, he says, part of this is I have a judge's order to collect your DNA. Then at 13:29 into the phone call, Detective Marples says to Mr. Castro, can you come to the police department tonight and I can give you a copy of the court judge order to get your DNA. He said, I'd rather not go to your house. You're an adult. You can explain it to your parents, not me. And then Mr. Castro says, why are you collecting my DNA? And Detective Marples says, based on circumstances in the area, the judge signed that I was allowed to connect DNA to rule you in or out as a suspect. And then they talk about coming in that night when Mr. Castro gets off of work, and Detective Marples initially says, I'll send you a text with the address, come there and just ask for people, and you can do this. Then afterwards, he texts him, and it appears that text did not make it into the record, But there's testimony in the motions hearing about the text that says, we can't do it now. Would you come in tomorrow morning? Mr. Castro doesn't respond.
Counsel, didn't the text actually say, please respond with the time tomorrow that you might be able to come in?
Your Honor, my recollection from the record is that it said, come in tomorrow morning at 9:30. But if the court has better...
Well, maybe the text does say that, but since we don't have it in the record, I'm just relying on the testimony about the text.
Right, and I will defer to the testimony in the record. I don't recall that specifically. I can state that about 9:35, 9:45 the next morning, Detective Marples and Detective Wills came over to Mr. Castro's home. He let them in. They asked if they could come in. He said sure, and that whole conversation was recorded. And that's the conversation that is the basis, the guts of the appeal, and that's the conversation that is problematic under Harris, problematic under the 41-1. The trial...
Can I ask you, I just want to make sure, and I'm glad I want to pick up on your mentioning 41.1 in Harris, because sort of going back to where you started about sort of separating or trying to separate the different issues you've raised on appeal, your first one, as far as I understand, is based on Harris, the 41.1 order case law, and the Fourth Amendment, because Harris is only a Fourth Amendment case. And so if that's the case, is it relevant at all to your first issue whether he was in custody for Miranda purposes during the February 5th conversation?
According to the trial court, I don't think the trial court analyzed it in that way. And I think that analysis kind of is what I'm saying, I think, as part of them being different and being the same. I think it was custodial interrogation under Miranda and the Fifth Amendment, and also problematic under Harris and using the 41-1 order to expand something that they didn't have yet.
But go ahead.
Oh, go ahead.
Well, in your first issue in your opening brief, which is the 41.1 Harris issue, you don't mention the Miranda custody factors. You do that in your second issue, sure. But the first issue is all about Harris and the Fourth Amendment and search and seizure and seizing without probable cause. And of course, seizure is custody under the Fourth Amendment, we call it seizure, right. But that's different from custody under the Fifth Amendment for Miranda. So again, I'm trying to figure out why it would matter or why it would be dispositive for your first issue, whether or not Mr. Castro was in custody for Miranda purposes.
I think he was in custody within the meaning of the 41-1 as soon as the officers appeared at his home the next day, because Mr. Castro knew of the 41-1. Because he had been advised of that 3 different times. I think that was like the situation in Minjarez when the officer went to the meeting with the defendant in that case with the warrant literally in her pocket.
So if that's the case, and following up on Judge Navarro's question, if the court were to determine that he was seized under the Fourth Amendment because of the 41-1 order at the February 5th, interview, do we even need to get to Miranda?
No, I don't think you do. I think that ends it there. And I think that's and I'll confess, that's
Now, does it end it for both the February 4th call and the definitely in terms of your analysis, it's the February 5th. What happens to the February 4th call?
I don't think there was, you could say that it was improper under the first call. And I don't think the issue with the first call, I don't think is suppression. I think the trial court was correct in not suppressing the first phone call.
Oh, so you're not challenging the denial of the suppression as of February 4th?
Correct. Only of February 5th. So under Harris, then we go to those factors in Harris, which is the subjective intent of the police, the objective assessment of the actions, the identity of the party who initiated the conversation, and the physical environment of the suspect. Obviously, those kind of dovetail with the Miranda analysis as well, but focusing on Harris, the detention occurred at this time of the interaction. And I would like to direct your attention to the 41-1 order, which I found on page 136 of the court file. It's also listed as discovery page 7 at the bottom of it. But what I want to draw your attention to is the order says, you are therefore commanded to detain forthwith the above named person for only such time as necessary to obtain non-testamentary testimonial identification and such procedures shall be conducted expeditiously. So that shows that as soon as those officers came to the home the next day, the order was being executed, just like an arrest warrant. And Rule 41.1 uses a little bit different word. Rule 41.1 indicates that take into custody, doesn't just say detain forthwith. So again, our position is that once the officers showed up at Mr. Castro's home, they were doing the 41.1, and he should have been detained forthwith with a non-testimonial identification conducted expeditiously.
But counsel, isn't it important that he knew or what he knew about the Rule 41.1 order? Like if they had never told him about it, just because they had it in their pocket and it had all this harsh language in it, it would be like Minhares. If he didn't know about it, it doesn't matter because under the Fourth Amendment, we have to consider what a reasonable person would believe under the circumstances. So we have to consider what they actually knew.
I agree, and I think him knowing that there was a court order for him to go to the police station and give DNA evidence, it makes this a different situation than Minhares. So I think that's why I say everything kind of rolls into everything else in this case. So when we're talking about the Fourth Amendment analysis under Harris, the Fifth Amendment analysis of whether this was custody, the trial court only looked at the Miranda analysis in the way I read the order. They didn't go through the factors from Harris. I think the trial court said he wasn't in custody. They came to his home. She applied the factors much as as counsel applied the factors in the brief for Miranda and said it wasn't custodial interrogation. And I think there was custodial interrogation. I think that was custody because of what he knew. So there was custody under Miranda, and there was also a problem under 41.1 and extending this detention, extending his custody, so they would ask him the questions before. I think it's important to note, and I take it for a different reason than the trial court did, which the trial court noted the last thing they did was formally arrest Mr. Castro. They formally put him under arrest, they formally put him in handcuffs, and then directed him out of his home. But they knew they had the right, and Mr. Castro knew they had the right to detain him as soon as they got to his house, and that detention should have been limited to getting the buccal swabs and digital photographs of his body to obtain the DNA. Instead, they did like Harris, which is they got the information and they kept asking for more. And in Harris, it's different because there was a Miranda waiver, so the only analysis is the Fourth Amendment analysis. But there wasn't a Miranda waiver here. There wasn't even a Miranda advisement, and I think that makes it different. And I've got 4 minutes left. I'd like to save that for rebuttal unless the court has any questions.
Thank you, you may.
Thank you.
Good afternoon, and may it please the court. My name is Tara Lisar, attorney registration number 58201, and I represent the people in this matter. The trial court correctly denied defendant's motion to suppress for the following 3 reasons. First, defendant was not in custody. Second, the 41.1 order does not change the custody analysis. And third, the concerns in Harris are not present here. I would like to begin by addressing Judge Navarro's question regarding the text messages the day before the detectives went to the defendant's home. On court file page 7, there is a description from one of the officers about the text message, and it says simply that they texted the defendant, and I asked Velasquez to pick a time during the day tomorrow, February 5th, 2020, and I would meet with him. We don't have the text messages in the record, so we are relying on the officer's report when discussing the text messages. I would also like to address the issue of all of these issues kind of coming together, as opposing counsel mentioned. Judge Navarro, you asked if it was relevant that he was in custody and whether this is a Fifth Amendment case. And yes, the custody issue here is completely relevant. And the Matheny factors, as the trial court discussed, ruled against custody.
But counsel, when you say custody, do you mean custody for Miranda purposes? Is that what you're talking
Yes,
about?
I mean custody for Miranda purposes. The
Okay,
defendant.
if that's, why would that be relevant to the Fourth Amendment issue that's raised first? You don't have to be in custody for purposes of Miranda in order to be seized under the Fourth Amendment, which is what the first issue is.
The first issue, yes, it discusses the Fourth Amendment seizure issue. However, it also discusses the Fifth Amendment because there was no Miranda advisement. However, it discusses the Matheny factors and whether an objective, reasonable person would feel restrained to the degree associated with a formal arrest, and that's under the Fifth Amendment.
Yeah, I understand that some of the briefs in the court order talks about it. My question is why? Because the Fourth Amendment issue is not concerned with whether someone's in custody for Miranda. It's a lower standard for seizure.
It's discussing the Fifth Amendment incriminating statements that the defendant made to the detectives during the interview, the in-person interview. And those self-incriminating statements apply under the Fifth Amendment. So that's why we're discussing custody under the Fifth Amendment and the Matheny factors, which I will now get to.
So,
Wait, go ahead.
so are you saying that the rule 41.1 that if you are seized, then and if you start making incriminating statements, then suddenly we're under Miranda? Like it's not a separate analysis under seizure versus Miranda?
I am saying that the Miranda analysis was relevant to the trial court's decision in deciding not to suppress the defendant's statements. They specifically relied on the Matheny factors because the 41.1 order did not alter the custody analysis for the Matheny factors when under the Fifth Amendment.
So I think that's the question that we're having. Well, I can speak for myself. If the officers report to his home because they have an order, the 41.1 order, and that is a seizure. Let's assume that was a seizure. Then, the Harris case talks about, look, you don't get to sort of like circumvent this limited intrusion that's allowed under 41.1 by kind of, going down the Fifth Amendment route. I mean, you still have to deal with the seizure and statements made under the seizure component, the Fourth Amendment. And so I understand that what you're telling us is, look, the court ultimately got to a Fifth Amendment because these statements were made. But I think what I would like to know is how am I bridging that gap, taking me from there's a seizure with an order that says you can do very limited things and case law that says, you can't use that to exploit and conduct an interrogation. How do we get past that to ever get to, these whatever factors, to think about whether there was coercion or free will or anything like that? Bridge
Yes.
that gap for me.
Yes, the 41.1 order was not executed until after the conclusion of the detective's interview with the defendant. And so when discussing seizure, the 41.1 order discusses detaining forthwith, as opposing counsel mentioned, but that did not apply until after the detectives executed the 41.1 and arrested the defendant and transported him to the police station. But that did not.
Fact that he knew about the 41.1 the day before. I mean, this isn't a situation where like he doesn't know about it, like Judge Navarro said. He knows that they have an order.
Yes, you're correct. On the February 4th, 2020 phone call, the detectives told defendant that there was an order to collect the defendant's DNA, and they asked the defendant to come to the police station. They never asked the defendant to go to collect the DNA at his home or at a hospital or at another location. And furthermore, during this phone call, they never mentioned the 41.1 order by name, and they never said the defendant was under arrest. And they asked but not demanded that defendant come to the police station. As opposing counsel mentioned, during that phone call, the defendant was going to work, and the detectives just asked, well, can you come in afterwards? Like, would that be okay? Would that work with your schedule? They never demanded he come to the station. They never seized him at that point. And later that night, when they texted the defendant ignored the text messages, and the defendant did not even show up to the police station the next day after they texted him asking to come. And so when detectives told defendant they had an order, it was very limited information that they gave the defendant. And they said that it must be at the police station, not at the defendant's home or at another location. So looking at an objective, reasonable person privy to this conversation, they would think that the detectives only had a right to collect the defendant's DNA at the police station, not at his home.
Well, okay, I see that point. I agree with you there. But so when the police proceed, they don't hear back from him on the text.
Yes.
They know the police are looking for him and want him to come to the station because they have an order to collect his DNA. And they show up unannounced early the next morning, 2 people. And you think when they showed up at his house, he knows they have this order and he has to go to the police station to execute it. They suddenly show up at his house, that he would have felt free to leave and disengage with the police and just walk away from them at that point?
Yes, he would have, because a reasonable person would have thought, okay, the DNA collection happens at the police station, and police officers regularly can come to a potential suspect's home and ask them questions.
Right, but most people don't have a court order for the police to collect their DNA down to the police station.
Yes, that's correct. Most people don't have a court order, but the court order was not executed at that time. And when detectives came to the defendant's home, they never mentioned the 41.1 order.
Well, they had mentioned it like less than 24 hours earlier. Do you think he would have forgotten about it?
He never showed up. He never responded to text messages. He never showed up to the police station.
So you think he forgot about the order, the Rule 41.1 order that was mentioned the night before?
He either, I don't want to speculate, he could have forgotten about it, or
Would
he
a
could have just not taken it
reasonable
seriously.
person have forgotten about it?
A reasonable person would have believed that the DNA collection was happening at the police station and not at his home. So a reasonable person would think, okay, the detectives have further questions for me, like they asked on the phone call the day before.
So are you saying that when they show up, that he says, oh yeah, we talked about this order, maybe they didn't say it by name, 41.1, and I guess you're here to collect me, but you can only do that at the police station, and I refuse to go, and you're telling me that the police officers would have just left his home?
No, but the police officers didn't execute the 41.1 until after the interview.
But that's the whole point, is that they were there to execute it, so that there was no need for them to start talking about this stuff with him, except for the fact that it was in their favor to do so. So, like, if they wanted to just go and pick him up and say, look, it's not going to happen at your home, we have to go to the police station, that's a totally different issue than let's talk about this stuff and then we'll, quote unquote, execute the order.
Yes, but custody happens on a continuum, right? So on one end, you have cases like Harris, where a 41.1 is executed, and then the detectives are speaking with the defendant and asking him all these questions during the collection of DNA, which was improper. But on this spectrum, you have detectives going to the defendant's home and asking questions first in an interview-style question-answer format, and then subsequently executing the 41.1 order for the collection of DNA evidence.
So I think what you're saying, and this gets back to what my question was before, if I understand you, is there was no seizure until they actually arrested him.
Yes, Your Honor.
And so anything that happens before that arrest is pre-seizure, and so Fourth Amendment protections don't apply.
Yes, Your Honor.
Okay.
And the opposing counsel mentioned Harris, and they said that the only difference was a Miranda waiver in Harris. But actually, Harris is distinguishable from this case for several reasons. Harris, first, is a 41.1 violation. Here, however, there's no 41.1 violation because the order was not executed until the end of the interview with the detectives. And in Harris, after the 41.1 was executed, defendant was questioned in the police car, at the hospital, on the way to the lineup, and at the police lineup. And this was improper under the 41.1 order. However, in this case, after the order was served, defendant was expeditiously taken to the police station. A third police officer was called to transport the defendant, and there were no further questions asked when the 41.1 was executed and the defendant was taken to the police station for the collection of DNA. Furthermore, the defendant was asked questions in his home, and he could have declined to answer those questions. He also did not have to invite the detectives inside his home. When the detectives showed up in his home, he invited them in. He told them to take a seat, and he chose to answer their questions. He didn't have to do any of those things.
Because you think he could have just walked away from them?
He could have refused to answer their questions, or he could have refused to allow them inside his home. Legally, he was within his rights to do
Even
so.
though they had the 41.1 order?
They never mentioned the 41.1 order
But
when
he
they
knew
initially.
about
day.
it. He obviously knew about it.
He knew that there was an order to collect his DNA, but he didn't know anything beyond that.
So you think he could have just closed the door or else jumped in his car and drove away and he would have felt free to do that?
I think he could have closed the door, and then the detectives would have knocked, and then they could have executed the 41.1, and then at that point he would have been seized.
Okay.
There is no. I understand your point, Judge
I'm
Navarro.
sorry. I'm not trying to make fun of you. And I realize you didn't write the brief, and you're doing a really good job. Forgive me.
I understand
I
your.
guess, counsel, part of this is like getting to what my concern is, Harris kind of goes through some significant pains to point out that they need to be treated differently because the policies behind each of them are different and that one should not be used to exploit the other. And so that's where I'm having a little difficulty with, and you probably were going to get to this at some point in your argument, the testimony of the officers were like, yeah, we were going to use this order and we're going to go and gather information. We wanted to execute this and we wanted to gather information. I mean, they say, it can be interpreted to be read as we were exploiting the order to go beyond its scope. So can you address that a little bit for me?
Yes, absolutely. In Harris, there was a hidden agenda. And the hidden agenda was to collect as much information from the defendant and get the defendant to admit to any crimes that were committed. And during the suppression hearing in Harris, the detective admitted to that. They said, yeah, we did have a plan going into it. We had pre-planned this, and there was that hidden agenda. Here, there was no hidden agenda, and at the suppression hearing, the defendant had the right, opposing counsel had the right to cross-examine Detective Marples, and they never asked whether there was a hidden agenda or there was a hidden scope.
Without him saying I had a hidden agenda, he says I intended to gather information and see what else we could find out. And they were saying we were going to the home under the guise of having this, under the authority of having this order. So, just because they didn't say the words, we have a hidden agenda, don't we have to consider that, especially given the kind of the strong language of Harris about how we need to be mindful of the different protections?
Yes, we do need to be mindful of the different protections. However, the Colorado Supreme Court in Min-Jerez discussed that an officer's unarticulated plan has no bearing on whether an individual is in custody for Miranda purposes, unless that plan specifically affects how a reasonable person would perceive that situation. So here it is an objective analysis and an objective reasonable person, not discussing whether an officer's unarticulated plan would have any bearing on the custody analysis. Next, the opposing counsel discussed the Harris factors. And to the extent that the Harris factors overlap, I will briefly discuss the subjective intent of the police officers in executing the order. The suppression hearing, as I mentioned, the questioning the defendant was never part of the plan. They never specifically testified to that. And as a result, in summary, the Matheny factors strongly weigh against custody, and the 41.1 order was not executed until after the conclusion of the police interview. Therefore, the suppression order was properly entered, and this court should affirm. Thank you.
Thank you, counsel.
And again, I apologize for chuckling earlier.
Oh, that's
it wasn't
okay,
at you.
Judge
You did a
Navarro.
great job.
Thank you.
Mr. Narum, you have just 1 second shy of 4 minutes left.
Thank you, Judge. What does execution mean? Does execution happen when magic words are said, or does it happen by actions? And it's clear, even though the Boulder Police Department that was involved in Harris was the same police department that was involved in this investigation, didn't slip up and say, oh yeah, that was our plan all along. It was clearly the plan all along. If you listen to Exhibit 2, which was the interrogation of Mr. Castro, it was, I hate to say this, it was pretty skillfully done. It was done by someone who was very prepared with the allegations, had read the police reports, had done a lot of the legwork already. It was clear that it was very skillfully done and it was planned. It wasn't just a happenstance of, oh, well, we'll go there to execute this, but we won't say the magic words until the end because we don't have probable cause to get an arrest warrant because there would have been an arrest warrant at that point. Instead, they got the probable cause for the arrest warrant during the execution of the order. The execution didn't happen at the end, and the choice to not start the process by handing Mr. Castro a copy of the 41-1 order, which would have shown how it was limited to the form of buccal swabs and digital photographs of the entire body. It wasn't a chance for a fishing expedition. As the court noted in the Harris case, just found it, Rule 41-1 talks about non-testimonial identification. In that case, there was not an interrogation. The defendant began by saying things, but the rule is limited to non-testimonial identification evidence only and does not authorize the acquisition of testimonial communications protected by the privilege against self-incrimination.
Counsel, I have a question about what happened in the arguments below at the suppression hearing. My understanding, and I guess the trial court's understanding of the prosecution's worry or argument was, are the police supposed to stop all investigation of the offenses once they get a Rule 41.1 order?
No, but they're supposed to limit their investigation into the terms of what the order they have. So they need to execute expeditiously and detain forthwith pursuant to the order. So that should happen first. And then afterwards, they can do additional investigation and additional whatever they need to do. But when they're there to comply with a 41-1, they need to do that first. They can't hold that in their back pocket and go on a fishing expedition and get the defendant to say things that he shouldn't have said, and then that's the process. Once they go through the steps to get that order, that's what they needed to do.
So in a hypothetical where, because some of his family members were there, like the mother lets him in, or I don't know for sure who was there, but a family member lets the police in, they're all sitting around, and maybe the police are just asking questions of the family members, and the defendant is present, and then the defendant volunteers stuff. My understanding of your position is that at the point they're on the doorstep, they are attempting to execute. So whether or not he is maybe volunteering stuff is going to be a gray area. If they're talking to other family members in the furtherance of investigation.
I think that's a different kettle of fish. I don't think that's a different situation that I hadn't thought of before the court asked me that. But I think the point is, yes, the execution happened when they knocked on the door. The execution actually started happening the night before, but when they showed up after he didn't respond, that was executing the order. Whether the police called it that, whether the trial judge called it that, whether the attorney general calls it that, execution happened when they showed up and had the order to take him in. Thank you.
Thank you, counsel. Thank you to both counsel for your briefing, for your argument. The matter will be People versus Pantaleon. Counsel for appellant, when you are ready to proceed, please approach and you may.
Thank you, Your Honor. Bob Driscoll, registration 5729 for appellant defendant, Mr. Pantaleon. Good afternoon, Your Honors. It's a tremendous honor to be here. This, folks, is an onerous case in light of the fact that the consequences are ultimate for the defendant. The conduct alleged in the complaint is, I'd call it medieval, but it would be an insult to the medieval times. The precedent, recent precedent, Coons and Cooper, on which the primary issue finds its foundation, its legs, are perhaps more inhumane than that alleged here, but to debate that is futile. I come with a big ask, the biggest ask to a court of appeals, especially in the face of standing recent precedent, but in cases of this gravity, I think we, as the bar and the bench, are called upon to bring our better selves, our highest selves. I'm asking for the court to find plain error at the trial level, notwithstanding my predecessor counsel's failure to, or decision, his option not to oppose the testimony of a general sexual assault or a general behavioral evidence expert witness.
Counsel, when you phrase it that way, that the defense counsel below exercised the option not to oppose this expert evidence, doesn't that sound like a waiver of this claim?
Perhaps it was, but I think it's a call for another court, the trial court, in a different sort of proceeding, competence of counsel, and so forth. The fact is, of course, as Your Honor has observed, the fact is that after a fairly arduous voir dire of the expert witness on November 9, in pages about 9 to 24, that's where that happened, just for ease of reference later, predecessor counsel sort of mid-sentence announced to the court, I don't oppose the witness. At which point the court certified the witness, accepted, I wrote it down so I could be wrong, but something like the court accepts the witness, Miss Miller, as an expert in child sexual assaults, behavior, dynamic, and responses. I'm not sure what the court could have left out in that broad sweeping acknowledgement of expertise, incidentally, without Daubert or Daubert, but I think it's commonly Daubert, hearing without Colorado's equivalent Schreck hearing. The witness was introduced, and there was a brief colloquy between the prosecutor and the witness. The witness was then tendered to defense counsel. Defense counsel examined the witness significantly relative to a censure that may have been a hickey on the neck of her credentials, and then announced that they didn't oppose the witness. The court then accepted the witness on that broad basis.
So I just want to be clear, counsel. I mean, as to what I understand, one of your claims on appeal is that the trial court erred, and we should review for plain error.
Yes.
Whether the expert was improperly accepted as an expert, and the reasons for that your argument is that there was no Schreck hearing, even though there wasn't one requested. Can you help me understand that?
I'll try. Your Honor, the Coons and Cooper cases are informative in light of Chief Justice, the Supreme Court's opinion, and the parsing analysis that the author, the Chief Justice, did in both cases. And
you agree with us that we are bound by the Supreme Court precedent.
I understand, and I'm hoping I can convince you that being bound by those cases, you may find plain error. And that is vested in the instructions in the instructions, in the opinion, that the court, that, may I? That the court make careful consideration to consider whether an expert's testimony, first of all, on the third prong, we're limited by the third prong of Schreck and Daubert, and that is the helpfulness to the jury, and not to exceed from helpfulness into prejudice or prejudice to the, even though it's relevant, that it's not overly prejudicial, given that context of the rules of evidence. Chief Justice Samore cautioned that even though he endorsed the witnesses in those two cases, Coons, where the sadomasochistic advances or actions by an older man and his girlfriend against a young woman through high school and college and into the military and blackmail and so forth, that's the conduct that was considered there. The trial court attempted to limit the expert witness's testimony based on a domestic violence wheel, a power and control wheel. It was very complex.
Counsel, even assuming somehow there's a way for us to avoid Supreme Court precedent on Cooper and Coons, I didn't see any argument of how this would satisfy the second prong or the third prong of plain error. I mean, there was no argument that, like, even assuming Ms. Miller, who was generalized expert, hadn't talked with the victim at all, didn't know the facts, that the testimony, while maybe abhorrent to you in the concept of having a generalized expert on these matters, that the evidence wasn't sufficient enough that the conviction can still be upheld.
Thank you. And my response would be the instruction of the Supreme Court in both Cooper and Coons that the trial court is instructed to exercise its supervisory power relative to expert general or bucket experts to permit all of their testimony, some of their testimony, or none of their testimony.
I get
and there
that.
was no. I didn't mean.
No, I'm sorry. I get that. I get that you don't think it's a tight fit or you don't like the generalized expert concept. But what I'm trying to get at is, where is the plain error analysis that, I mean, let's avoid even obviousness, because I don't know how a district court judge can say Cooper and Coons doesn't exist, so I'm going to not allow this testimony in. But notwithstanding that, how did it substantially affect the verdict?
Well, we don't know because the court, and in response to your specific question, Your Honor, the court refrained from exercising its supervisory power. It was obligated, and just recalling chronologically, this case was a very short time, within months after the pair, Coons and Cooper had been, the order came out and the opinion came out in those cases, and the Jefferson County District Court refrained from any supervision of the expert witness.
Okay, counsel, you keep describing what you think is the error that happened, but you have to show more than that an error occurred.
Okay.
You have to show that it substantially prejudiced your client, but nowhere in your brief do you talk about prejudice or the effect of the error.
If I may, I'll do that now.
Well, we usually don't allow arguments for the first time at orals, but you could try.
Well, in the testimony, in the colloquy between the district attorney and the expert witness at trial, the district attorney inquired into 8 separate topics. The immediacy of report, the fear of consequences to the testifying victim that would cause delay in reporting, fear of support system, that the support system wouldn't believe the reporting victim, fear that the events may have been caused by the victim, fear that the phenomenon of a testifying victim, a youthful victim, might lump events chronologically and not be able to distinguish what happened one year or one season or at night in the day from the other because of the aging and maturing of the brain. The fact that the perpetrator, the defendant, could have been, was in this case, a family member, and that dynamics effect on the credibility of the witness. The timing of the decision to report, which in this case was something like 10 years after the onset of the sexual contact alleged. And finally, the concept of grooming. So there were 8 separate, desperate topics, none of which were specifically qualified by the supervising magistrate, the trial court judge, nor was there any attempt by anybody which would give rise to the supervising court's duty to supervise the testimony of the witness, say what's going to be the testimony, and limit the testimony to one or more of these topics, or to qualify the expert in one or more of these topics. As the court, I'm sure, recalls, the testimony of the expert was that they've been testifying 230 times on cross-examination. It probably was 260 times for prosecution only. They'd been in practice as a social worker for almost 30 years, I think 28. They teach at DU. Okay, fine, but what do you know about sexual assault? There was no development of the expert's expertise relative to the dynamics of human behavior in the face of sexual assault. And I, in response, I guess, delayed response to Judge Johnson's interrogation or question of me, forgive me, but you got me, I proffer that would be, that's where I see the plain error, the lack of supervision by the district court judge, the lack of specificity in the qualification of the expert witness, no record being made, there's no record at all of the first scientific basis, the second and fourth prong of Daubert-Schreck, and I submit the court could find a plain error and remand the matter for a new trial, and I better save a minute.
Thank you. You may.
Thank you.
Good afternoon, Your Honors. May it please the court. Lane Towery on behalf of the people, bar number 59161. Mr. Pantaleon's claim that admission of a general expert amounts to reversible error fails at every level. In the first instance, admission of this expert involved a textbook, if not routine application of binding Supreme Court precedent in Cooper and in Coons, as has been discussed. Those cases had come down mere months before the trial in this case. And those cases establish, along with plenty of appellate precedent before them, that admission of a blind expert speaking on a topic that is helpful to the jury, like the counterintuitive behaviors of a child victim of sexual assault, is admissible. There was no error in this trial. Without any error, certainly, I don't think that opposing counsel, either in briefing or at oral argument, can establish the even higher standard of plain error. I haven't heard him meeting his burden on either obviousness or on the heightened standard of highly prejudicialness.
Counsel, can you address whether you believe, based on the record, that the issue of the qualification of the expert was waived?
Yeah, gladly. Whether this court decides this issue on waiver or on plain error, I think the result is the same. So I don't really have any intent of fighting the court hard on this, but with your invitation, I'd like to make my strongest case for why this was waived. Waiver is, my first answer is just the simple principle that waiver is antecedent to the merits. And so I think that it's not exactly jurisdictional, but it's sort of akin to standing, that if there was a waiver, this court doesn't even need to get to the merits. And I think if there's a waiver, this court should stand by that. In this case, I think there was a waiver because there was a knowing and intentional waiver. Trial counsel was first notified that this witness was going to be testifying months before trial. He chose not to file a motion in limine or a motion to exclude. Trial counsel was given an opportunity to voir dire, but did not request a Shrek hearing that might have developed a record on which this court could make a decision. He chose not to object. After probing, he probed very actively in voir dire, specifically along the lines of the rule that came down in Coons about whether or not this expert would be helpful to the jury. And when he didn't get an answer that allowed him to object, he made the decision very immediately. He said, "I do not object." Whether or not that was any sort of real strategic purpose, as some people might find in a waiver context, or whether or not that was just, I think, the ethically correct decision, that he had no meritorious objection, I think that shows that there was knowledge that he could object, consideration of how to object, and then an intentional decision not to object. I think on all those grounds, that adds up to almost a paradigmatic waiver in this case.
Thank you.
Yeah, you're very welcome. I really don't want to belabor these points any further, Your Honors. If the court doesn't have any more questions, I think we're happy to rest on our briefs otherwise.
I have a quick question.
Please.
Under Shrek and its subsequent cases, they impose this gatekeeping duty on the trial court to make specific findings about relevance and fit and reliability for any expert evidence that's offered. Do we have those findings in this case?
No, I don't believe the judge made explicit findings about relevance on the record. There is case law from this court in other cases that weren't raised in the briefing, but where actually this, not just expert witnesses generally, but this specific expert witness was admissible and affirming the trial court's decision to admit her even after not making an explicit relevance finding on the record. And the Court of Appeals in that case said that it was because her relevance was obvious and because she had been qualified as an expert hundreds of times previously.
Thank you.
Yeah, you're
Was
welcome.
that based on her specifically, or was it the type of, information or expertise that she was speaking about?
In the prior case, Your Honor? That's a good question. I don't recall that other case closely enough to tell you exactly what it was, but I think both are at play. In this case, we have a clear record where she describes her 30 years of qualifications working with youth, specifically in the case of sexual abuse of youth. I don't think in this case there's any record that would even begin to question her personal qualifications.
I realize there's the waiver issue, but I wonder, part of the brief, as I understood it from the defense counsel, is that some of this stuff is obvious to lay people anyway. So it's not just obvious that she might have relevant testimony, but it's obvious that I think one of the arguments was that delayed reporting is pretty well known given a lot of the sexual assault scandals that we've read about in the news. Can you talk to me at all about at least that argument that maybe some of this is overly broad that we have generalized experts talk about?
I think it's certainly plausible that the day might come when the rule articulated in Coons and Cooper gets limited by a specific factual finding that some specific topic is so widely known amongst the public that a generalized expert is no longer necessary. I think that sort of finding would require a really clear record developed on that question. And in this case, not only do we not have a record, but the record that we do have shows the opposite. In voir dire, the trial counsel specifically asked the expert, the defense counsel has to say, "Do you believe that what you're testifying to is outside the knowledge and experience of the average person?" She said, "Yes, I do." He asked her, hasn't the public been inundated with that information that is about delayed outcry, such that they have knowledge of this without your expertise? And she said, no. I think the dynamics that we might see in children who have been sexually abused are not common knowledge or obvious. I don't think the average person knows extensively about the dynamics of sexual abuse in children. So I think in the abstract, it's an interesting question about the future. I think in this case, there's really no record to support a finding of that kind.
Thank you.
Well, whether it's on waiver or on plain error or on both, people request that the court affirm the conviction below. Thank you, Your Honors.
Thank you, counsel.
Since I have the last shot.
You
I'll
have
give
about
just-
a minute and 9 seconds.
Thank you. Thank you for your patience. I submit that in this case, to inquire of the witness whether their testimony is valuable is like asking Colonel Sanders if you should eat chicken. The testimony in this case of the expert witness, I believe, was a vehicle utilized only to bolster the credibility of the witness and put the prosecution's thumb on the scale of credibility. I rest and ask respectfully for a reversal and a remand.
Thank you, counsel. Thank you to both counsel for your briefing and your argument. The case will stand submitted. We'll issue an opinion in due course. And that concludes this afternoon's setting. And so the court will be adjourned and the bailiff may so announce.
All rise. The court will be in recess, subject to call.